In 1793, a controversial Supreme Court opinion convinced Congress to amend the U.S. Constitution to provide a better safeguard for federalism. Indeed, even the Federalists in the first Congress viewed the majority opinion in Chisholm v. Georgia as a clear example of federal overreach. In this video, I'll explain why. During the War for Independence, Georgia accrued debt to be paid to Alexander Chisholm of South Carolina, who was then acting as the executor for the estate of Robert Farquhar. About a decade later, in 1787, the Philadelphia Convention drafted a new constitution. The new document would only be put into legal effect when 9 states individually ratified it. By 1788, the Constitution achieved this benchmark, and 11 states ratified by the time George Washington was inaugurated as the first president of the United States. At this point, North Carolina and Rhode Island acted as independent republics. Under the new Constitution, the condition of sovereign immunity in federal court was stressed several times by the Federalists, who were then acting as the chief advocates of the new framework. For example, in Federalist 81, Alexander Hamilton declared that it was inherent in the nature of sovereignty not to be amenable to the suit of an individual without its consent. This is the general sense, Hamilton continued, and the general practice of mankind, and the exemption, as one of the attributes of sovereignty, is now enjoyed by the government of every state in the Union. He added that suits by individuals against another state are only binding on the conscience of the sovereign and have no pretensions to a compulsion of force. Such suits compelled no action, Hamilton explained, independent of the sovereign will. Even so, the Supreme Court appeared to violate this precept when it took up the case of Chisholm in the 1790s. Instead of acting as a willing participant, Georgia refused to represent itself in court on the basis that the state did not consent to the suit. Therefore, Georgia argued, the state's sovereign immunity prevented the federal courts from having the power to hear the case. Nevertheless, the Supreme Court did hear the case of Chisholm and decided to side with the plaintiff. In a 4-1 decision, the J Court opined that Chisholm was due payment from Georgia in accordance with Chisholm's legal position. The lone dissenter, Justice James Iredell, objected to the decision because the Constitution did not grant federal courts the power to hear the case without Georgia's consent. According to Iredell, there was no doubt that neither in the state now in question nor in any other in the Union any particular legislative mode authorizing a compulsory suit for the recovery of money against a state. After the controversial opinion, Congress quickly mobilized to overturn the judgment through a constitutional amendment. Even though sovereign immunity was implicitly granted under the unamended Constitution, it appeared necessary to add an explicit amendment to reiterate this principle. The 11th Amendment, as it was soon to be, clarified that states hold sovereign immunity against suits made by citizens of other states in federal court. In essence, the Supreme Court could not hear such a case if a state did not provide its authorization. Illustrating the widespread appeal of the amendment, even the Federalists in Congress perceived the embrace of federalism to be a necessary action. Federalist Caleb Strong of Massachusetts drafted the version of the amendment in the Senate, while Theodore Sedgwick took the primary role in the House of Representatives. Even so, the bipartisan nature of the 11th Amendment was unambiguous. The amendment secured an overwhelming majority of 81-9 in the House of Representatives and 23-2 in the Senate. By 1795, the requisite number of states ratified the amendment, putting it into legal effect. The amendment manifestly reversed the Chisholm opinion and dismissed the legal ramifications of the J Court's judgment. Although the modern Supreme Court assumes the role of final arbiter over every constitutional controversy, it was never meant to be so. Instead, the founders and framers intended for the whims of the federal judiciary to be checked and superseded by Congress and the states through judicial stripping and the amendment process. As such, the case of Chisholm v. Georgia and the subsequent passage of the 11th Amendment underscored the Federalist orientation of the Union and the primacy of the states. In my book, Compact to the Republic, I explained how Chisholm v. Georgia undermined the original intent of the U.S. Constitution. I'll include a link to that below in the notes, and I'll also include the best links on Chisholm v. Georgia. Thank you for watching this episode of History in a Nutshell. If you enjoyed this video, please subscribe to my channel and check out my other videos.